Welcome to a brief tutorial on evaluating legal sources. By the end of this tutorial, you should be able to evaluate the authority of information from various sources and identify the different levels of authority of sources used in legal research. A good way to evaluate information is by thinking of the 6 question words: who, what, where, when, why, and how. Who wrote it? Who is the author? What authority do they have to write about this topic? A lawyer writing a law review article is likely an authority on the topic, but a women's studies professor writing about a legal issue that intersects with women's studies, for example, employer coverage of birth control, could also be an authority. What type of document is it? Is it a court case, a law review, a report from an NGO, a newspaper article? All of these may be authoritative sources, but you would use a court case differently from an NGO report in your writing. Where was it published? This is more important with secondary sources. Anyone can publish a blog post, but something published in a law review or a scholarly journal, for example in psychology, has gone through a review process to ensure the accuracy of the information. So, while a think tank report may be accurate, it doesn't go through the same review process a scholarly article does. That is where someone, another scholar or person in the discipline, reviews an article before it can be accepted for publication. When was it published? Does the date matter? If you are referencing an older court case, for example, it's important to check to make sure the legal principles are still valid and haven't been overturned by subsequent decisions. If you're noting the status of a law, for example, gun ownership in all 50 states, using law review articles from the 1990s wouldn't be the best evidence for that claim, as laws change and today might be very different from the 1990s. Why did the author write this? What was their purpose? For a law review article, this is likely to inform or maybe persuade you to a legal position. For a think tank report, the think tank may have a strong left or right-leaning bias and an agenda to promote. So, while all sources have a bias, some are more pronounced than others, and every source needs to be viewed with a critical lens. Even primary legal sources. A court ruling can often reflect the values of a particular time but don't hold up well over time. For example, the Dred Scott decision. Finally, how did the author gather and use data and evidence? For example, a think tank or partisan publication might only report favorable or unfavorable statistics about an issue. Pro tip, if you see a statement, statistic, or piece of evidence that doesn't correspond to anything else you've read on the topic, there might be something fishy going on. With legal research, a source can be authoritative but may not be the best evidence for a legal argument. Sources that are very solid to use in a political science research paper may not be so for a legal research paper. For example, a scholarly article from an interdisciplinary field such as women's studies. You may get authoritative data from the article, for example, statistics on spousal abuse, but it wouldn't necessarily be able to be used to support a legal argument. For example, what is the law on spousal abuse? In legal writing, there are levels of evidence and authority. Some sources may be good, but not as high an authority in legal research. The highest level of authority are the scholarly primary legal documents, those cases, statutes, constitutions, agency decisions, and regulations. Law review articles are authoritative, scholarly, secondary sources. When writing a memo or a brief for a class, you must cite relevant mandatory authority, but you can also cite persuasive authority if no mandatory authority exists, or to add support to the mandatory authority you cited. Mandatory authority are the primary sources, for example, higher court opinions the court must follow because it is binding on the court. Persuasive are those primary sources a court can choose to follow, for example, from another jurisdiction or a lower court, and also secondary sources, such as law review articles. Now let's answer a couple of questions about what you just learned.